I want to say hello to our audience and welcome. You are listening to Gemini Legal Podcast. We are interviewing subject matter experts, industry thought leaders. We are here live. We have a special podcast here. We're live at the California Applicant Attorneys Association here in Rancho Mirage. Very beautiful weather. I am Dan Mora. I am not an attorney. I am the CEO and founder of Gemini Legal. We provide legal discovery services for California workers' compensation. And I have a very special guest, one of the most gentle gentlemen in this industry, John Bloom. John, would you introduce yourself? Tell us a little bit about yourself.
Yeah, hey, good afternoon. I'm John Bloom. I'm a long-term trial lawyer, but I do administrative trial work, no jury work. Traditionally, I advocate entitlements for disabled people. I'm a California certified specialist in the realm of workers' compensation. And so I've been doing this for a lot of decades. It's a very satisfying path for me professionally. Keeps me shaking hands and hugging adversaries and helping the bench make the right decisions and doing good deeds for disabled people. So that's kind of what my little mama papa law firm is all about. I'm in Santa Rosa, California. Ever hear of it?
I've heard of Santa Rosa, California. Beautiful place as well.
Yeah, we grow a lot of grapes there, and on a good day, they actually squeeze them into red wine for guys like me.
Yeah, what a beautiful place to be and start your practice. How long have you been in Santa Rosa now?
I have been in Santa Rosa for a lot of decades. I had practiced law for 5 years in the LA area after I graduated law school in the 70s, and kind of burnt out on the practice after 5 years or so of bumping into the walls of the courthouse, and thought it was time to get out of town in Southern California. It wasn't quite ringing my bell for a lot of reasons, and moved onto the floor of a good buddy for 3 months in Sausalito. He let me pull out a sleeping bag and look at the wonderful people walking through town, and decided to land my new life there, and then made the ridiculous decision to open up my own practice. And I've built my clientele one client at a time, case by case, from that time forward. That was back in 1982 when I made that move.
Amazing, yeah. And
it's amazing that I'm still alive, right?
You look great. Don't worry about it.
Oh.
So you have a fire in your belly about injured workers, and I'm curious. How do you keep that flame going? How do you help your clients and help them see that you're necessary, but also that they need help?
Well, in a lot of circumstances, a person can wind up knocked down in life, and pretty soon, if it ever occurs to them to file a claim with an insurance interest or a self-insured interest, there are some very big obstacles quickly erected by the defense. And it gets harder and harder for them to make their way through what I call the jungle of a very heavily regulated field of practice. On-the-job injury law, workers' compensation, and other realms of disability entitlements can be quite complicated. So it dawns on people somewhere down the road of their claim that they really don't understand their rights, and more particularly, they don't understand the procedures necessary to access justice. And, that's kind of where my training and experience comes in. I have some experience here over the last several decades, accessing little people who have been knocked down with disability, accessing justice. And that's kind of that's probably an overused phrase, justice, but, people who have their claims have rights. And I help people enforce those rights, and there's something very sweet in the attorney-client relationship that arises between me and my clients that really blows my dress up, so to speak. It makes me happy to have something to offer to bring to the table of somebody who's actually in need of help.
Yeah.
And so it's my knowledge of procedures that I think is paramount.
Yeah.
And also kind of my, disinterest in letting giant insurance corporations railroad little people into dust. I'm not going to set the world on fire, but one client at a time, I find it very gratifying to walk them through this jungle of overregulated entitlements.
Yeah, we could be making widgets, but we're actually helping people.
Yeah, and it's really a one client at a time experience for me. That was one of the reasons I began leaving the Southern California area. It was just too many people, too many claims, too much responsibility on my part to handle 600 claims at a time. I'm one of those people that might have a hard time walking and chewing gum at the same time without falling. I like to actually get to know my clients, and I do. It's absolutely astonishing how representing people over the last 35 years or so in the Santa Rosa area, a little one-horse town an hour north of San Francisco, the diaspora of my clients as they filter out into the world is astonishing. I've had clients come over to me in a basement breakfast room in Florence, Italy, where I'm having a breakfast with my daughter 6,000 miles away. And they come over to me, recognize me. Hey, are you John the lawyer from Santa Rosa? And I go, whoa, who wants to know? It's very funny. It's like Buenos Aires, Paris, wherever I go, there's a Santa Rosa client I've worked for over the last many decades. So it's a very grassroots connectedness that I experience, and I get a lot of value out of that in my adult life.
Yeah, that service-based leadership is it's hard to replace that high.
It is, and Gemini Legal has done an amazing job of accessing the tools that I need to advance the rights of my clients, because a lot of what we do is paper heavy. And there are records created through the course of time, and Gemini Legal goes out and gets those records so that when it comes time for me to develop a medical platform of expert opinion evidence or a vocational platform of expert opinion evidence, I've got the hardware to stand on, to feed to the experts, to bring their opinions into the realm of substantial expert opinions. Courts like that stuff.
Yeah. I have a question for you. So there's a labor code, it's 5708, and let me just read it to you, and then I'd like to get what your thoughts are on this.
Good, okay. I really like being spoon-fed the labor code. Go ahead.
So 5708, and it says, let's see, that this is talking about the appeals board in the conduct and their conduct shall not be bound by the common law or statutory rules of evidence and procedure. Now, the way I read that, and the way that we've received some feedback from judges on objections and quashes, is that they have a red pen that says that they can ignore evidence and procedure statutory rules. This is what I do, this is what I live on, and I think that's very dangerous. What's your thoughts on that? For lack of a better term, slippery slope, or when people don't like evidence, they start to discount it in that way.
Well, pretty much the role of the bench is a complex task. There are a lot of elements that have to be brought into the analysis of any particular legal issue. There are a few judges that are going to admit that they want to, or are willing to, or have disregarded the law. It's their job to apply the law, but there's a lot of discretion accorded the bench, particularly in the administrative law forum called Workers' Compensation Appeals Board. On the other hand, no judge can ignore the evidence, and no judge is permitted to ignore the law. But the Constitutional Court of the Workers' Compensation Appeals Board has its own internal rules of court, Work Comp Appeals Board rules, and other regulatory authority that they work within This is not a court of general jurisdiction. They're a very specific, refined court that has very specific parameters of evaluation. So I doubt that you're going to find any judge that completely disregards statutory or regulatory law. But on the other hand, somewhere between the narrow focus of what the work comp judges do and the regulations and statutes that bind their responsibilities, they're also duty-bound to look at the facts. So as an advocate, I suppose you show up with liens to be honored or not, or petitions to quash certain subpoena duces tecum that are issued. If you're going to oppose any of those proceedings, it's your burden of going forward to show a judge why he or she should rule in your favor. And, it's a complex path.
Gotcha.
Even for trained professionals like yourself, I imagine.
Gotcha. Yeah, it's a concern for us in the discovery area that there is, a red pen, basically, the way in that labor code that could, use discretion that's maybe not. Of course, they have a duty, and I would never question that, that motive, but it's a concern that somebody could make an argument and all of a sudden evidence is not accessible or not available.
Well, as an advocate, it's your job to make sure that the evidence you want to rely on is in front of the trier of fact. That's my job too when I'm in court representing a client. I'm hopeful that there's not too much abuse of discretion that you've run into, but frankly, over the last several years, I've seen a lot of petitions to quash being subpoenas for records that I issue. There are a lot of subpoenas and objections that are raised by the insurance world to defeat the processing of getting those records for a multiplicity of reasons. If they can deprive me of getting my hands on much needed information that's the subject of the subpoena I've asked you to process for me, then they're stripping me of my ability to do my job. And if they file a timely petition to quash, I may still get those records, but then they try to use that petition to get out of having to pay the costs associated with the request for records that Gemini has always been really amazingly efficient at getting. So either way, those are two very strong motivations for the insurance defense world to tangle with you. And unfortunately, these kinds of costs are not always treated by judges as the meat and potatoes of what the labor code is designed to accomplish. And so there may be a tendency that you're seeing for judges that get inundated with these petitions to quash filed by the insurance world. They get inundated, they get buried in the paper, and they just want to flip it off their desk, out of their thought process in as expedient a way as possible. So it's your job to make sure that the bench is doing its job in a way that is judicial, consistent with the canons of judicial ethics and traditional notions of fairness in the context of evidence.
Love it.
Yeah.
So
a lot of words, huh?
Man, you're great.
Sorry.
So you were. Tell us about the panel that you were on this morning. What were you talking about to the membership here?
Okay. Well, I was selected to moderate a panel of amazing presenters. The people on my panel this afternoon were absolutely in a class of their own. Very, very highly accomplished, brilliant women and men. I was so proud to work with them to prepare for today's presentation on the subject of, pardon the phrase, substantial evidence, quote unquote.
Substantial evidence.
Yeah, woo! You should hear a drum roll when you hear that word,
substantial evidence.
Yeah, it's like there are very few practice guide books that are published with a chapter titled Substantial Evidence.
What does that mean?
That's what today's 70-minute program was all about, what it means and interestingly, even though there are not a lot of horn books or practice guides that have a chapter on the subject, every single book should have an entire chapter devoted to the subject because the importance and the need for quality evidence in front of the courts is necessary on every single issue that trial lawyers are required to go in there and prove up. And I see the question or the issue of, is this substantial evidence, raised every single case I go to court on, and I go to court 4 days a week, every week.
Wow.
And the insurance world loves to challenge the quality and character, the depth and sustaining drill down information on the evidence being presented to support my client's case in direct. So I go out and I gather evidence, I manufacture evidence when it doesn't exist out there on its own, and I bundle it and then I bring it to court in support of my client's contentions. And then the insurance interest steps up and says, oh, this isn't really real evidence, is it? It's manufactured, or it's disingenuous, or it's not factually correct, or it's relying on the wrong legal principles, or any one of 500 other arguments. We see it on every case.
Wow.
And so I really think that the Education Committee came up with a timely, appropriate subject called substantial evidence. And there were 800 lawyers attending this afternoon's program on that subject, and many of them have come over to me privately after the fact saying, wow, those were nuggets of gold. We deal with it all the time. And, thanks for the primer.
So 2 questions. Is there substance to the, substance to the defense, but is there also, what are the tips that you're giving when it comes to fighting that question about substantial evidence?
Well, I think, at my point in my own growth and development as an advocate, the greatest, strongest, bestest tip that I can give is we're all kind of in this thing together, whether you're a defense attorney, an applicant's advocate, a judge, whether you're a lien claimant, or anybody else that's stepping up into the forum called workers' compensation and other forums. We're all doing this together, and we should all be focusing on what constitutes real, meaty, substantial information that a reasonable mind can look to rely on to carry the proponent's burden of proof. The burden of proof under the California Evidence Code is a double banger. If you've got the burden of proof, you've got to get the evidence to move forward, but you also have to make sure that evidence is persuasive to sustain your position in front of a trier of fact. Mm-hmm. So, every case turns on the facts inherent and inimical to that particular case. And, I suppose if I did insurance defense work, I'll never do insurance defense work, but I suppose if I did it, I'd raise substantial evidence too and try to poke holes in the evidence that my client's adversary has put together for the judge. And like that. So, But we're all doing it together. We should all be looking at the same elements, whether you're a defense interest or an applicant's interest, makes no difference. And I think actually, as I support my co-practitioners, my colleagues in the community, to develop a record that really sustains any particular proposition that they're trying to achieve, it makes the judge job so much simpler. Hey, I've got a meaty record here. I can use my, experience and discretion to come up with the right answers.
So, can you give me an example of what substantial evidence maybe is?
Yeah, it's sometimes a little hard to pinpoint it. It's sort of like, you know it when you see it, but it's really hard to define in advance. But I worked really diligently with this panel to define it in advance so that all of my colleagues can kind of, put something in their hip pocket to take back to their office on Monday morning and use.
Right.
So an example of what is substantial evidence is, I can't give you a comprehensive example, but suffice it to say that the cases that have come down from the California courts are fairly they're fairly good on leading us to know what to do.
Okay.
And here's basically what they say. They say that substantial evidence has got to be meaty, it's got to go to the heart of what it is that you're talking about, it's got to be thorough, and it's got to pass the reasonable mind test. You can't take an unreasonable proposition and then pawn that off as substantial evidence. And The bottom line is, if there's an element that might be missing from, let's say, a comprehensive medical report that's got 32 elements in it, but one of them's a little bit soft, part of my job is to throw out to my colleagues on a presentation like this, hey, what do you do to fill in the missing pieces? But you have to be smart enough to see that there's a piece that's missing. You don't want to go to a judge with something short of substantial to carry your burden of proof. That's part of our job as trial lawyers, is to recognize what is substantial and what is not. What's missing from this report? And it's not just medical evidence, it's vocational evidence, it's evidence of job duties. There are a lot of places where this shows up. We have to be on guard and alert for all of that at all times in our gathering evidence and then perfecting it so that you turn it over to a judge and the judge can see, oh yeah, I get it, that's what this party wants to accomplish. Then they get to turn to the other side. Counsel, can you rebut this? Do you have anything to beat this down with? Do you have better evidence than this? Or can you show that the evidence that is before us is defective in some way? And there are a lot of ways to attack that stuff. And that's what we as lawyers look at all the time. Whether you're working for the disabled party or the insurance interest, we look at the soft spots in the other side's evidence.
Gotcha.
It's kind of the wrestling match that we go through every case. I love the wrestling match. I'm pretty good when it comes to mud and blood and beer.
And beer. So, I'm asking this question, you have a magic wand. I'm hearing a lot about access to and the availability of quality medical care. Do you feel like that is the biggest issue we're dealing with in workers' compensation right now?
Yeah, it is. It's kind of the elephant's head in the room, this medical care. They say that everything in work comp is driven by medical. But, the overriding goal of asserting a claim for an on-the-job injury, for example, is to get better and go back to work. It's like there's no substitute for your own inherent earning capacity, and you don't achieve that unless you're back to work. Let's get everybody up and rolling and back to work. Unfortunately, it's expensive in the not so remote past. It was very expensive to allow doctors to have a presumptively correct opinion as to what's needed next, because a lot of doctors that are recommending healthcare don't look at the bottom line like an insurance company does. So what does the insurance industry do? They go into Sacramento, they go get some protective legislation that now short circuits the open opportunity for an injured worker to select their own doctor and substitute a medical provider network. Who stocks the doctors on the MPN, the medical provider network? The insurance company. And there's no regulation that says that once they're on an MPN, they have to be kept on it. If the insurance company whimsically doesn't want to carry that doctor forward, they have every right in the world to knock them off. Well, who are they knocking off the MPNs? The doctors that are costing them money, because what's the overriding goal of an insurance interest? It's to save money. Their articles of incorporation are all about maximizing profiteering for the corporate owners.
Yeah.
So what's their battle cry? Knock off the doctors that are costing them money. Well, the ones that are left after a period of 10 years, 12 years, 15 years since Senate Bill 899, the ones that are still left on the medical provider networks are doctors that are saving them money. Well, is this last remaining group of physicians actually providing really good medical care to their patient? Or is there some kind of a big foot in the exam room with the doctor and the patient called the insurance company that the doctors are appealing to so as to maintain their status on the medical provider network? So it's kind of a no-win situation for little disabled people in many situations. But I will say, with all that having been said and what I've watched over these years, even though there's a shrinking group of quality medical providers in the work comp realm, I'm very happy to report that there are still groups of high-quality, conscientious, ethical physicians that remember the Hippocratic Oath, that take care of their patients first, everybody else last, And, that's very redeeming. We in the business know who's doing what to whom.
Gotcha.
And we have our ways of helping disabled people get directed to the healthcare providers that are really making a positive difference for the patient.
Right. And you guys have a tough job understanding the medical side and the legal side. And the same with the doctors, right? I hear that a lot, that the doctors, their understanding of how to evaluate a claim and then write a report is a significant area of education that I think caused trying to put their best foot forward to educate the doctors. But the complexity is real, and I commend you for you and your peers and the doctors in this industry for navigating that complexity.
Well, thank you for that. That's very articulate, and it points out an interesting concept. A lot of the healthcare providers that are not professional forensic evaluators, a lot of the treating doctors that are on these medical provider networks take a training course that might last 2 hours to get oriented to on-the-job injuries, or maybe 15 hours of training. Well, you give a doc 15 hours of training and they have some rudimentary early entry orientation, but zero experience at evaluating these sometimes very complex issues. And so what happens is you can have just a whole host of treating physicians that sort of kind of get the generic idea of what is and is not allowable in the work comp realm, but they're really not expert like the forensic evaluators. There are agreed medical examiners who litigating parties can select who are extremely accomplished, very learned, very familiar with the law and the medicine. And then there are QMEs, qualified medical examiners from the medical panel, that are also very highly technically trained. There are a couple of rummies on the panels that we run into from time to time, but mostly these are extremely well-informed, well-trained forensic experts. By forensic, I mean they evaluate for the purpose of testimony in a court of law.
Gotcha.
Yeah, so it's a great subject matter, actually. It's an endless process of getting the doc on the phone and saying, hey, doc, could I just orient you for a minute as to what the law actually says here? And here's what your patient's telling you. You just wrote that in your report, but have you put 2 and 2 together to come up with 4 yet?
Right. What a tough job to understand all the guidelines, and I have great respect for those that practice in this realm.
Yeah, I feel very sorry for the docs that want to get into the forensic world and then, have to deal with advocates that can't wait to challenge their opinions. It's not an easy path. I have many times said to physicians that I'm cross-examining, hey, I don't envy your role here, bud. This is not an easy program, particularly with guys like me in the room.
So final question, where's the hope? Where's the hope? The injured workers, they need our help, and they've had a series of attacks over the years. And where's the hope?
Yeah, that's a great question and a great subject to wrap up our chat on the subject matter, because hope is something that I don't really subscribe to as a generator of activity. I don't get up in the morning and hope for the best. I kind of like to stir the pot and make my own luck, so to speak, if you know what I mean. I kind of like to go out and make things happen. But it's an interesting concept. I think many minds deal with hope every minute of every day. I really hope that this thing works out. And there is hope in the context of what is hope. To me, hope is very passive. Stirring the pot and making trouble, now that's active. But, it's hopefully, going in the same direction. And I do think that I, who have watched over 4 decades of reform legislation through time, every year being promoted in a way that is diminishing liability to the insurance world and diminishing entitlements to disabled people, I have watched groups of lawyers not walk, but run out of the business of trial law in work comp because they didn't think they'd be able to make a living after that. But those who are dedicated to advancing the rights of disabled people stay with it. And there's always a way to make this system work. And my clients, they're not all enamored with workers' compensation. I don't know many people who are. But they come out on top. And, we can't rewrite the law as advocates, but we can make the law work individually in a case-by-case setting to make sure that our clients come out on top. Whatever the top of the barrel is, that's where I strive to take them. And that's where every injured worker should have the hope to get to. And if they can't figure out how to do it themselves, let them put in their circle somebody who knows how to access justice.
Well put, John.
Good to talk to you.
Thank you so much for your time, and thank you for your advocacy. You're a humble man, but thank you for participating. I really appreciate it.
Well, thanks for having me chat with you, and thanks for doing such great work in support of my practice. I really appreciate it.
You got it, John.
All right, cheers.
Take care.